Hi, this is criminal defense attorney Stephen G. Cobb, and today's frequently asked question is, will my lawyer be there when I turn myself in on an arrest warrant? And the answer is only if they don't know what they're doing. Now that sounds pretty harsh, but let me explain why. It's because you don't want your lawyer there when you turn yourself in on an arrest warrant, because you're going to have first appearance the following morning, because most of the counties in this particular circuit normally use video first appearance. Now there are some judges, one comes to mind, for example, in Santa Rosa, another one comes to mind as well in a different county in this circuit, and they will actually go to the jail to do first appearance, but only if it's on weekends. So normally, if you turn yourself in on an arrest warrant, you're going to see a judge, and you're going to be standing in front of a television screen, and the judge is going to be in a video courtroom with a video link, and the two of you will communicate at first appearance. And the judge is going to make three basic decisions. Number one, is there probable cause? Well, if you have a warrant, the answer is usually yes, that's already been determined. Two, is the person entitled to bond? And if the answer is yes, yes to that question, what amount and what conditions? So where you want your lawyer is not there when you turn yourself in. You want your lawyer sitting off screen with the judge. Why? Because, man, that's the first time a lawyer gets to look at an arrest report, and it's one of the fastest things you ever do in criminal law, because what happens is the judge will have reviewed a stack of arrest reports. Usually everybody who gets arrested during a 24-hour period, at some point they're going to see somebody from pretrial release services, and they're going to do a screening, pretrial release screening. And then after that, certain recommendations and forms are filled out, and it goes to the judge. So the judge reviews them, and then sometimes, literally seconds before you're called to go in front of the screen, your lawyer engages in speed reading. That's why a lot of us actually know how to speed read. It's because we may get, a half page or a 3 or 4 page arrest report and see it for the first time. And the next thing you know, we're arguing for a bond. And that can be pretty difficult. So it's important for your lawyer not to be with you at video court. Now, if you have a public defender, quite often, in some counties, because different counties do it differently, we have one set of Florida rules of criminal procedure, one set of statutes, but in the real world, we have different procedures in different places. Normally, though, you're going to want your lawyer, if you have a privately retained lawyer, not with you in the jail at all, unless the judge is going to be there. Other than that, you want your judge and you want your lawyer seated right next to each other, so that you may not be able to see your lawyer, but your lawyer is going to be able to make argument on your behalf as to why you should have a bond and have the lowest bond possible. If you have any other questions about the arrest warrant or criminal process in the state of Florida, feel free to give me a call. Stephen Cobb, 850-423-0035.